And for a moment of silence, and then we will have the Pledge of Allegiance led by Councilmember Nunn. Thank you. All right, thank you.
I pledge allegiance
To the flag of the United States of America and to the republic for which it stands, one nation, under God, indivisible, with liberty and justice for all. All right, Madam Clerk, roll call.
Vice Mayor McPartlin.
here.
Councilmember Nunn.
Here.
Councilmember Matthews.
Present.
Councilmember Dodd.
Here.
And Mayor Jones.
Here. All right, Council, I would like to, we have one agenda modification, if you all don't mind, to pull item 8A. Something happened with those records, and we need to bring them back at a future meeting. I'd like to have that pulled. Any objections?
No.
All right, are there any other modifications to the agenda? Hearing none, we will proceed. Next thing we have is the brief announcements, and Councilmember Nunn.
Yes, sir. The January 28th Treasure Coast Astronomical Society Stargaze has been canceled. So you can go out there on the 28th. It's going to be cold, but there will be nobody there doing any stargazing. February 3rd, it will be rescheduled, by the way. It's just not that night. February 3rd, you have the Four Chaplains ceremony at Veterans Memorial Park at 11 a.m. February 7th, the Sebastian River Art Club event at Riverview Park from 10 a.m. to 3 p.m. That'll do it.
All right, thank you so much for that, Mr. Nunn. Now we have item is public input, and this is a portion of our agenda where you want to speak on anything that's not on the current agenda. So do we have anyone who would like to speak on anything that's not on the current agenda? Yes, sir, come forward.
Can't hear you all up there.
Thank you, Mr. Mayor. Check. Can everybody hear me out there? I want to take the opportunity to thank certain council people from the last meeting, since didn't get a chance to speak after their vote. This affected a family that's been in the community for over 40 years and another family who's been operating a cleaning business on Harrison Drive by the No Name Sports Bar. And that decision that you made to proceed with option C under the plan that the Parks and Recreation recommended to this council to approve, you approved. Councilman Dodd, Councilman Sherry, Councilman Vice Mayor Bob McPartlin, you listened to your staff, you listened to your committees, and you made the right decision to benefit this community because it affected a lot of things down there on Indian River Drive where everybody comes together as a community. You're going to be building a big band shell down there. You're going to be drawing a lot of traffic, and you decided to leave the roads open. It was an engineering decision that you decided. And Sherry, I know you pondered very hard on that decision. You thought very hardly about it, and you did a good job. As the new councilwoman on this dais, you made a good decision. You didn't let politics play a role in making your decision. I'm a little disappointed with you, Mr. Mayor, and I'm talking to you directly, and you, sir, Mr. Nunn, because you're experienced and you should have known better. You should have known better. We offered you property to purchase. If you want to take away our private property rights, purchase them. Don't just take them by eminent domain and shutting down roads. We were there before the park. And I'm glad that we have 3 council people up there that really dive into the information and look at the details on how it's going to affect this community. Because that is Park Place on the Monopoly Board. It's important. It's the center of where we come together as a community. And they did a good job. And I hope tonight, Mr. Nunn and Mr. Mayor, you take time to decide what you're going to decide for all these people tonight. It's a big decision. It's in our CRA. It's part of our CRA. Coming
Sir,
in
we
and out
haven't
of it.
got to that. If you want to talk about that, you can, this is under public input, so don't even start
I
going
apo-
in that direction, okay?
I apologize.
Thank you.
So, tonight, please, take time to think about what you're going to do. Appreciate it.
right.
Thank you, Mr. Mayor.
All right, thank you, sir. We always do. Appreciate your time. Anyone else? Is there anyone on Zoom on the public input?
No one has raised their hand.
All right, hearing none, public input is closed. Council consent agenda, what say you?
I move approval.
Second.
All right, all right, we have a motion and a second. Is there any other discussion on that? Hearing none, Madam Clerk?
Councilmember Nunn.
Yes.
Councilmember Matthews.
Yes.
Councilmember Dodd.
Yes.
Mayor Jones.
Yes.
And Vice Mayor McPartlin.
Yes.
Motion carries.
All right, thank you so much. Any committee reports? Anyone? All right, hearing none, we're going to go into public hearings now. We're at public hearing, item 10A, consideration of an appeal request regarding denial by the Planning and Zoning Commission. Who's Mr. Stokes?
Yes, sir. As just a few preliminaries regarding this. This is a matter that came before the Planning and Zoning Board, or Planning and Zoning Commission, regarding a conditional use in addition to two other items which are companions with this. They're all done as one item. The Planning and Zoning Commission voted to deny it, and an appeal was taken, which is a procedure that is set out in our code. Pursuant to our code, what the council is doing at this point is you're sitting in an appellate capacity. So this is not a new hearing on the matter or a second hearing on the matter. This is an appeal. This is a review. You are reviewing what the Planning and Zoning Board saw, and your determination, the first determination is whether they got it right, made an error, didn't make an error, whatever, and you can decide to either overturn it or to modify it or to uphold it. If you decide to modify it or overturn it, you kind of have a hybrid role, because now you're sitting in the capacity as the Planning and Zoning Commission, because you have the authority under our code to grant the conditional use or grant it in some modified form. So because it's an appeal, you're reviewing the record below, including all the comments. I know all 5 of you have watched the meeting, so you've seen all the comments that were made by everyone that spoke at that meeting, including the attorney that made a presentation. You've received the minutes to the meeting. You've received the entire packet. And so at this point, the appellant is represented by counsel. The HOA is represented by counsel. You can hear arguments from both of those sides, and then open it for deliberation at that point. Also, staff's here as a resource for you as well. So.
Right, okay, so I would, next thing, I'd like both attorneys to come up representing their clients to come forward, please.
Mr. Mayor, can I ask a question for you?
Yes, sir.
Okay, this is for the attorney. There were 3 unique items presented to the Planning and Zoning Commission. One was the site plan, and one was the conditional use, and one was a waiver. Okay, and in watching that meeting, I couldn't really tell that they ruled on those 3 items independently. Can you please just give me some insight into what the actual motion, which of those 3 the motion turned down, or was it all 3? I wasn't really clear on that.
Well, and thank you for bringing that up, because there was confusion at the end of the meeting, because the initial motion and vote was just for the conditional use. We then had them keep, because it came to them as one item. It was one item in 3 parts. And so it came as a package. And we chose to keep it as a package, because otherwise, if this appeal had been taken on the conditional use and you reverse the planning and zoning, those other 2 items would still be hanging out there without any, determination. So that's why they reopened the meeting in order to keep it together as all three. And so there was clarification at the end of the meeting, and I know the video cut out and then came back on, but there was clarification at the end of the meeting that all three items were denied, and all three items have been appealed now
Okay.
to you. So
So for the
keeping it
purpose
as
of our hearing tonight, we're viewing all three items as though they were denied. And should we deal with them independently or as a group?
Yeah, and that's it, is because there are three parts to this. You're sitting in that role to review all three. So you can, like, let's say you reverse the conditional use, you could still have a problem with the waiver or with the site plan. I mean, you do have that ability to deal with each one individually, the same way they did.
All right. I just wanted to make sure we weren't confused at the end like they were.
Right. Yeah. The issue is the conditional use, and tonight also, I think you need to take up the conditional use first, because if the conditional use isn't granted, the other two are rendered moot. The other two only need to come into play if the conditional use is granted. So.
Okay. Thank you, Mr. Mayor.
All right, thank you so much. And the reason I asked you guys this, and I want to make sure everybody understands, our attorney just spoke about how this process goes. For those folks that are out there sitting in the audience, there's no new evidence coming before us. Everything that's already been presented is what we're going to be listening to tonight. So each side is represented by counsel, and counsel will display their case to us. So everybody understands what's going on.
And Mr. Mayor, just,
Yeah.
as part of our quasi-judicial ordinance, each side does have 30 minutes. I don't
Yes.
think either side plans on taking 30 minutes, but it's their time to do so that the appellant and the opponent can both put on as thorough of case as they want. So.
Absolutely. All right. Do you need to read the ordinance or?
No, there's not an ordinance caption here, so I can go ahead and read in the requested action. This is actually an appeal of a conditional use permit, site plan, and waiver for a 3.8 acre boat and RV storage facility with covered parking spaces, office building, washdown area, and RV dump station, along with improvements to landscaping, utilities, lighting, and stormwater. A concurrent waiver request from the Riverfront Overlay District requirements regarding front yard fence material is also included.
All right, thank you so much for that. Council, do we have any ex parte communications? Anyone here?
Mr. Mayor, I met with the appellant representatives, not the lawyer, but the individuals. It does not influence my decision process.
All right.
I also spoke to Mr. Bragnano on the phone about this situation, what's going on.
I spoke to Mr. Bragnano. He told me, to watch the meeting and that they would be appealing the decision.
And I also spoke to Mr. Bragnano, but it's nothing to do with my decisions.
Yes, absolutely, and so did I.
Okay.
I spoke to tell me talk about the case. I don't talk about that, but to make sure that this was coming before us. That after that P&Z meeting, that was going to come before us. Correct.
And just for clarification for the record, any emails that were received, I know a lot of emails received, those were all made part of the record.
Yeah.
So that if as this is all put together, any residents or homeowners that sent in emails, those are all part of the record as well.
All right, thank you so much for that. Next, we are going to have the applicant, if you want to come forward and present your case.
Good evening, Council. My name is Jonathan Rodeback from Dill Evans and Rodeback. I'm an attorney here in Sebastian, and I have the pleasure of representing the applicants in this case. We are taking up an appeal from the decision made by the Planning and Zoning Commission on December 18th of 2025, denying my client's application for conditional use, application for site plan, and denial of their waiver request. Specifically, under your code of ordinances, this talks about the scope of review, 54-1-2.4. subsection G4. It's mentioned in your agenda request form that sets forth the scope of review. You have the authority to reverse the Planning and Zoning Commission. You have the ability to affirm it wholly or partly, or you have the discretion to modify the Planning and Zoning Commission. Your review is limited to the record that is before you, which consists of the minutes. There was also the YouTube video that I referenced in the appeal request that has what happened exactly, a video of those proceedings. And you also have the documents, plans, papers that were presented to the Planning and Zoning Commission. The basis for the appeal is the applicant in this case met all of the requirements of the city's code of ordinances, the land development code, to be given or to be approved for a conditional use, have the site plan approved, and get a waiver request. At that juncture, the burden then shifts to those opposed to the application to show by competent substantial evidence why it should be denied. I think it's clear once you take a look at the record and see those proceedings that the Planning and Zoning Commission respectfully were reviewing this project in its legislative capacity as opposed to quasi-judicial. And I don't want to step on the shoes of your attorney, but there is a big difference between those two functions. Your legislative function is the function that you make determinations of what you feel will be good for the city. It's policy setting measures. Quasi-judicial, however, is applying a set criteria to certain facts in a case. So, for lack of a better analogy, consider the Planning and Zoning Commission and you tonight in the position as a judge. We have a set criteria. If you meet that criteria, you have to approve the application. You do not have the discretion because that is the criteria that is under your law. That's the difference between a legislative function and a quasi-judicial function. Before the deliberations started, before Planning and Zoning Commission, you will notice, or I'm sorry, not before the deliberations, but before the decision was rendered and the motion was made, that the member of the Planning and Zoning Commission, that member that made the motion, was struggling immensely to come up with a reason why to deny the project. And the reason why we're struggling with it is because it met all the requirements of your code. But the fallback is how this particular project failed to meet or to be designed, located, and proposed to be operated so that the public health, safety, and welfare was protected. Relying upon that, after getting some significant input from other commission members and council, it seemed that decision was based on layperson opinion of increased traffic and safety. And I don't want to belabor the point, but in your packet, I submitted to you some cases, one from not too far from here, where the city of Melbourne denied a conditional use application under similar circumstances, where layperson testimony was given that there was worry of increased traffic and safety, and that decision ultimately got overturned by the court system because that is not competent substantial evidence. Competent substantial evidence is that which a reasonable mind can be persuaded by something. And in this particular instance, when we talk about traffic and we talk about safety, we go to experts who you burden the applicant to retain in order to give expert analysis on what the impact towards traffic and road safety are going to be invoked by this project, and that's exactly what happened here. Mr. Schulke, who was here tonight, testified. He said all the evidence showed All the competent, qualified evidence showed that this project is going to have a de minimis impact on traffic and that it has been safely engineered and designed. Layperson's opinion of, I think it's just going to be worse, is not substantial, competent evidence warranting denial of a conditional use application. And that seemed to be ultimately what planning and zoning was focused on when it denied this application. Some of the other measures that came up. There was references to potential storage of gasoline or propane on the property. There is no hazardous risk here. Gasoline tanks are in our garages. We do that to fill up the lawnmower. There's nothing unique. They're not being asked to store biohazardous waste or anything out of the ordinary. There's laws preventing that, and this isn't that type of storage facility. So that too is completely and totally unwarranted. There were also comments made about, well, it's not that we're necessarily opposed to the project. We're opposed to the project being accessed from Ashbury Boulevard. Perhaps it should be accessed off of County Road 512. Answer is that would violate the plat, which contemplates the access point directly from Ashbury Boulevard, and Indian River County Code, which requires that it comes across from Ashbury Boulevard. That's why the entrance is designed to come there. And that is the substantial competent evidence to justify why the entrance has to be where it's contemplated to be. Other than that, there really was not a whole lot that was presented to the Planning and Zoning Commission in opposition to this project that warrants denial. Again, the legislative function has already been dealt with. You determined that this was a use that could be permitted under certain circumstances. This use is a conditional use that can be granted provided the conditional use criteria is met. My client met that criteria. It's right in your report. Your own staff who you hire, who you paid, agreed with that conclusion. They recommended that the conditional use application be approved, the site plan application be approved, that the waiver request be approved, and they slapped some conditions on there or recommend certain conditions be imposed that my client wholly was willing to meet. Everything in contravention of that was based on the fear that typically accompanies development. In planning and zoning, I made the same argument to them. The Ashbury residents, respectfully, it's often very scary when a new development comes near your property. But if planning is proper, the analysis is done, you can make good, educated decisions. That way, you can have a prosperous city. You don't just rely upon fear or whether warranted or not, that development is scary. The best example I can give you, and I'm not sure how many council members were around, is when Ashbury came in. This whole place was filled with individuals opposed because, oh my gosh, with new development comes increased traffic. It's going to result in car accidents. It's going to result in this, all the bad things that accompany development. It is scary. But with the right analysis, the right project, it is something that could be beneficial to the city. Respectfully, the analysis has been performed. Your staff has reviewed it and recommended its approval. And we respectfully submit that you do the same. And by doing that, you will have to, unfortunately, overturn the decision that was reached by Planning and Zoning Commission, which, again, we think they were acting in their legislative function based on a popularity context, not a quasi-judicial function, which was applying the facts to a set criteria. And because of that, I think tonight you have no other choice but to reverse that decision. I'm available for any questions. We have the engineer for the project here available for any questions that you have tonight. We think this is a good project. The impact that's going to be on the residents of Ashbury has been wholly minimized from an aesthetic standpoint, from a safety standpoint. In fact, if you take a look at the aerial of the project, which is in your plans, you'll notice that the only part where these properties somewhat intersect is in the back corner of the RV and boat storage facility, which is going to be buffered by a significant amount of trees on its property, then buffered again by a significant amount of trees on the Ashbury Clubhouse property. Otherwise, it isn't going to be visible hardly from any of the residents in Ashbury. It just only has a slight touching of the Ashbury Clubhouse right near Ashbury Boulevard. So tonight, at the conclusion of it all, and after you deliberate, I respectfully request that you overturn or reverse the decision of Planning and Zoning Commission with respect to all three decisions it made, which was the denial of the conditional use application, the denial of the site plan application, and the denial of our waiver request, and you ultimately rule in the favor of the applicant. Thank you very much.
All right, thank you so much for that, sir. Yes, sir.
Good evening. My name is TJ Izzo. I serve as general counsel for the Ashbury community. Ashbury is a residential association of 193 homes immediately adjacent to the proposed boat and RV storage facility. Because of this, our proximity, our community will be directly and significantly impacted by the proposed development and conditional use being sought to be appealed today. Many of the Ashbury residents are here tonight in supporting the commission's decision to deny the conditional use. I just want to point out some things to the council. Under section 54.1.2.4 G4, as the appellant's counsel just stated, your review is limited only to the testimony, documents, plans, papers, and other materials constituting the record upon which action was taken at the December 18th hearing. This does not include the appellant's appeal letter or any case law that was submitted after the fact, as that was not taken up at the hearing at that time. Under established Florida law, a quasi-judicial decision by a local government must be upheld if there is any competent, substantial evidence supported by the record. Your role here tonight is not to reweigh evidence or substitute your judgment, but to determine whether any competent, substantial evidence exists supporting the commission's decision. This deferential standard of review applies to the commission's or to the council's decision here today. The applicant bears the burden of demonstrating that the record fails to contain any competent, substantial evidence supporting the commission's decision. This is a significant burden, and the applicant did not meet. Section 54-2.6.2D of the Land Development Code establishes the clear conditional use criteria. Any approval must be granted only after the commission finds that the proposed conditional use, 1, is so designed, located, proposed to be operated so that the public health, safety, and welfare will be protected. It does not present any unduly adverse effect upon the properties in the impacted area. And based on the scale, intensity, and operation, the use will not generate any unreasonable noise, traffic, congestion, hazards to the contiguous residential areas. This is not merely a technical requirement. These represent fundamental protections existing in communities like Ashbury. The official record from the hearing in December 18th is replete with competent, substantial evidence demonstrating multiple grounds supporting the commission's decision, including detailed meeting minutes and extensive public testimony from affected Ashbury residents. The proposed conditional use with 24 access would generate unreasonable noise, traffic, and congestion affecting the Ashbury residents. The proposed entryway creates a critical safety hazard. Ashbury has only one single entrance lane into the community, and these large RVs and boats in close proximity where they queue and stack could effectively block the sole point of ingress and egress to the community. This presents an unreasonable burden on the 193 residents who depend on unobstructed access for daily living. Additionally, Ashbury Boulevard is a private roadway. It's very narrow, and it was never designed or contemplated to contemplate this type of development and simultaneous presence of large recreational vehicles stacking for facility access while residents attempt to enter and exit the neighborhood through a single lane. The public testimony from the December 18th hearing also addressed dangers at the Sebastian Boulevard intersection, a high-speed thoroughway known for numerous traffic collisions and, tragically, an intersection where an Ashbury resident recently lost their life just a few months ago. These facts underscore the critical importance of maintaining clear sightlines of oncoming traffic. The proposed facility with large RVs and entering and exiting the vehicles at all hours would create additional visual and obstructions and traffic conflicts, which already exist at a dangerous intersection, further compromising the safety of the residents attempting to access their homes. The meeting minutes also reflect that city staff noted uncertainty about why a public access easement was placed on a private roadway and reminded the commission before rendering its decision that it must find that the proposed use does not affect the public health and safety or cause any adverse effects on adjacent properties. The commission voted to deny the conditional use approval application on the grounds that this standard was not met based on competent substantial evidence upon which the decision was made. City staff's report for appealing for today's hearing recommends upholding the commission's denial. Staff properly recognized the limited scope of review and focused on the existing record. And this recommendation underscores the commission acted within its authority based on competent, substantial evidence supporting its decision reflected in the record. We respectfully request that the council uphold the decision by the commission. The official record contains ample, competent, substantial evidence demonstrating the conditional use proposed here would adversely and unduly affect public health and safety of the neighboring Ashbury community. The commission properly weighed this testimony, and the applicant has failed to demonstrate that the record failed to contain any competent, substantial evidence. Under the applicable legal standard and land development code, the commission's decision must be upheld. Thank you for your time and your consideration. I deeply appreciate the Planning and Zoning Commission's willingness to recognize the adverse impact this proposed use would present and their reasoned decision to protect our neighborhood. I'm here to take any questions.
All right, thank you all for that. Do you anybody up here have any questions for either one of the attorneys, or do you all want to hear what staff has to say before we go forward?
I do have one question. The last attorney made the statement that staff had made a recommendation to uphold the Planning and Zoning's decision. Is there something I missed in here? I didn't see
Thank
that.
you, because I did want to just clarify that on your cover sheet for this item, under the recommendation, we had recommended that you hold the quasi-judicial hearing and to either make a motion to reverse, uphold, or modify the Planning and Zoning Commission. Now, there may have been confusion because part of the packet that we gave you did have a staff report in it, but that constituted the record that was given to P&Z. So this is the same staff report that Planning and Zoning got, where yes, we did make a recommendation on those pages regarding with the conditions of approval. But with regards to a recommendation to this appeal, staff did not make any recommendation.
All right, thank you, Ms.
Chris, that's on page 160 of your...
Yeah, I just wanted to clarify that staff did not make a recommendation on this appeal.
Okay.
Thank you.
Anybody have any questions for, does staff need to say anything, Mr. Stokes?
Staff is primarily more of a resource, so if there are questions, they're ready to answer, but there's no presentation planned.
Okay.
Yeah, okay. I had one question. I thought this site, Ashbury, had another entry-exit point. They only have one entry there? Yes, sir.
That is correct. It's a private roadway from Sebastian Boulevard. It's a terminus engine.
Come to the mic.
No, you had to come up, sir. Sorry, man.
I apologize. The Ashbury Boulevard is a single terminus from Sebastian. It's perpendicular with Sebastian Boulevard and ends into the Ashbury community. At the entryway of Sebastian Boulevard and Ashbury Boulevard, which is the community's private roadway, is a public access easement that was on the plat or recorded plat, I should say, put there probably by the developer or whoever developed the property previously.
Right, but there's no other way in and out of that
That's a
community
single-
except
that's a
for that
single
point,
entrance
is what you're
Yes,
saying?
to my knowledge, sir, yes.
Okay. Thank you.
Mr. Mayor,
Yeah.
can staff provide clarification?
Yeah, okay.
I want to clarify. That is the main entranceway. There is a residential access point. However, guests and vendors have to use that.
Okay, well, that's fine. That's what I need to know, because that point was said here earlier, and I just wanted to clarify that and make sure that everyone know what was going on there. Yes.
That's fine. Okay, all right.
All right. Anybody else have anything, any questions for any attorneys, or do we want to go straight to deliberation?
Whatever the process is.
Well, I think we're just going to go, if you all have any questions for, if any of us have any questions for each one of the attorneys about any of the evidence or anything, this is the time to ask, because after that, we're going to go ahead and make a decision on what we're going to do, so.
I guess, Mr. Mayor, I have a question for Mr. Stokes.
Okay.
As I heard from the attorney said, all we can go on is what happened at the last meeting. We can't consider the case law that was brought up by Mr. Roadback on the appeal. Is that accurate?
I would actually respectfully disagree with Mr. Izzo, only because case law is, again, it's not facts. It was more part of the argument of the appellant, which is what lawyers do all the time. They show other cases to support their argument. But I just want to make sure counsel understands, if you rely on that, you're relying on it as an analogy in law, not as facts. So you can't rely on it as facts.
Thank you.
But you can rely on it as far as legal precedent if you find it applies.
All right, is that it for you, sir?
Yes.
Anyone else? All right.
I'm kind of confused.
All right.
That's not unusual.
I get confused all the time, too.
Yeah, I know. There's two things that I'm hearing in the presentations from the council, and one of them is that the Planning and Zoning Commission did not properly hear this. I heard that from the appellant's counsel, and I just kind of, no matter which way this is decided, I kind of disagree with that. They did exactly what we want the P&Z to do. They heard the evidence. They were given an opportunity to review that, and they made a decision. Their decision to deny this was based on page, I know you don't have this out there, 156, 158 of our thing, that they determined that the Planning and Zoning Commission did not find that proposed outdoor storage use is consistent or designed with local and proposed, all right, wrong one, with this public safety issue. Whether I agree or disagree with that doesn't matter. I think they made that decision based on what they heard and what they felt they heard. So I don't believe our Planning and Zoning Commission did anything in error. Well, that doesn't necessarily mean I agree with their thought process on this. It just means that I would not want it to be inferred that the people in our Planning and Zoning Commission did not properly hear this. I think that's a misnomer, and it's challenging when it doesn't need to be necessarily challenging. There are some issues, and I know we can't introduce new evidence, but there are some issues related with traffic safety in this particular application. I mean, we've got Sebastian Boulevard pulling into 512. We've got the prospect of there being some relatively long pieces of equipment pulling straight across 512 from Sebastian Boulevard. That does present a safety issue that someone could infer, means that it doesn't meet the public safety mess on this. I don't know that I fully agree with that because I don't think we're going to have that happen as much as people think it's going to happen. We're not going to have 55 or 60 large vehicles pulling straight across 512 from Sebastian Boulevard every day, I don't believe. I don't think that the use is designed to do that. Some of the notes that I made. As far as the entrance on and off Sebastian Boulevard, and this all was brought up during the hearing at the P&Z, okay, by either the Appellate's Council or by the staff. But I mean, the right-of-way off of Sebastian Boulevard was established by the developer towards the end of their involvement in the project. I think it was maybe the fourth plat that we received in the city in which that right-of-way was established, and that was done as they sold those two pieces of property. But it was established by the developer when that was placed in play. Whether that's right or wrong is immaterial to our decision point. They did establish the right-of-way. And so it's the question about whether the entrance or exit off Sebastian Boulevard should be done is an old decision that was made prior to the city being involved in this project. And I don't know there's anything that the city can use, any evidence that the city can use to say that that creates a problem for the particular project. There is a second entrance and exit off of Powerline Road. Theoretically, that could be used if there was a major tie-up on that facility. So that's my comments.
Mr. Mayor, I do have one other thing.
Yes, hang on. We're trying to conduct a meeting. Please.
Yeah, I do want to agree with Councilmember Dodd on one thing. I don't think after watching the meeting a couple times that even there was anything inappropriate. I know that Mr. Roberts was the one who made the original motion. For him, that was like the first real motion he had made at a planning and zoning meeting, and it wasn't that his motion was inappropriate. His motion was fresh. It was new. He had never done that before, so the process was new to him. So while it seemed very cumbersome while they were making the motion, it wasn't out of neglect or anything wrong. It just was a new planning and zoning member making his real first motion. So I do agree. They saw it properly, whether I agree or disagree with the outcome and results. The whole process was proper as it should have been. Thank you.
All right. Thank you. Anyone else, or we can go ahead and make a motion, unless we want to hear any final from the party?
Yeah, in our code, it does say that the appellant kind of gets the last word.
Yes, sir. You may come forward.
Yes, thank you again, Council. Just to address the arguments raised by Mr. Izzo respectfully, the traffic came up again, and the safety issue came up again. And the point that I was trying to make was not to throw planning and zoning under the bus or to say that they weren't listening or anything of the sort. You get a public hearing, you have a whole bunch of opinions that come before the commission, before the council. And from a legal standpoint, some have to be given more weight than others. And that's one of the reasons why, in connection with these applications, you require certain traffic analysis and engineering and things of that nature to ensure that when the project comes before you, that you don't have somebody, a layperson, not factoring in the proper criteria to design something that will be safe for your residents. The whole point I was trying to make during my initial presentation or my initial argument was that what planning and zoning perhaps was persuaded by and seemed to be persuaded by, and that seems more evidently so since Mr. Izzo focused on it, was the traffic, the increased traffic and safety. And the answer is you have nobody that presented before planning and zoning except for the applicant that could properly testify or give an opinion to be given any weight. And that's what the case law was purposely before you to show you that the city of Melbourne was similarly persuaded by such arguments and was ultimately overturned because respectfully, Residents get worried about increased traffic, but engineers are the ones that do the actual analysis and go through it, design it. That way we can put forth a project that is safe and has a de minimis impact on traffic, or if it does have an impact, that it's properly addressed. And that's what was done in this case. And that is why it's our opinion that this particular application meets the conditional use criteria. And respectfully, the planning and zoning was listening to an opinion that it probably should not have factored as much as it did so in its decision. Thank you.
Test. Now, yes, sir, you can come forward. Your final.
Thank you, everybody. I'll be very brief. The applicant's attorney brings up some good points. But the major point is we cannot reweigh the evidence. Public testimony by individuals who are directly impacted should be given credence. And in particular, several of those residents in their professional capacities, right, have that professional expertise. One of the residents who is reflected in the meeting minutes is the city planner for the city of Palm Beach, or Palm Beach, Alan?
Fred.
And nowhere in the land development code.
Thank you, sir. Please not speak from the audience. You may speak for them, all right?
Yes, Mayor. I just wanted to highlight a point that I don't think anywhere in the land development code where it dictates where credence gives to the credibility of a testimony, rather that the record reflect that the testimony was given and was supported by, that is competent substantial evidence which decision was made. The commission has deference to weigh each and every testimony, including everything that was introduced in the record. And it was their decision, based on the totality of the record, they rendered their decision. And I don't think here is to discount anybody's testimony from the paid engineers and experts by the developer. Thank you.
Thank you. Thank you so much. All right. Council?
Mr. Mayor, I have one other thing. I'm thinking about the traffic situation, and, I've been by boat and RV storage places, and I can't think of another business that had customers that would have less traffic than this. I mean, if it was a restaurant or something like that, that would be a huge amount of daily traffic and daily runs, and I just can't see that there's another type of business that would bring less traffic if that's the consideration. I've been by them. There's not a lot of traffic at them, and while the RVs and boats are big and they do like a garbage truck coming in and out, I mean, they will take up the road for a second, but they'll be gone pretty quickly into an exit. So to me, I don't see how that plays as the concern, because I think this would be the least amount of traffic that could be from a business being put there, and that's my thought.
All right. Thank you so much for that. And I just got one question for staff. What else can be put on that site? We're talking about, this is an RV and boat storage. What else can be included on that site?
The project is, the parcel is zoned commercial general, but it's commercial general within the Triangle Overlay District. So when that zoning was established, they removed some of the more intense uses that commercial general could have. And so I know Brian has a list of those. It's been tweaked from commercial general that stays on US 1 down there by Barber Street. But he, again, it's broken up to permitted and conditional uses, and Brian can read that.
Yes.
He has it.
Thank you, Dory.
Yeah.
Mr. Mayor, may I?
Yes.
Thank you, Mr. Mayor. So under the CG zone within the Triangle Overlay District, permitted uses include, and I'll read them entirely: cultural or civic facilities, churches, clubs and lodges, public and private, business and professional offices, excluding drive-through facilities, medical services, commercial retail less than or equal to 20,000 square feet, plant nurseries, restaurants, excluding drive-through facilities, trade and skilled services, hotels and motels, administrative services, public and private, accessory uses to permitted uses, home occupations, and all uses permitted within the RM8 zoning district. Those are all permitted uses. Conditional uses include bars and lounges, commercial retail greater than 20,000 square feet, business and professional offices with drive-through facilities, farmers markets, funeral homes, nursing homes, child care services, utilities, public and private, parks and recreation, public, protective and emergency services, public, restaurants with drive-through facilities, veterinary services, wholesale trades and services, commercial amusements enclosed, accessory uses to conditional uses, vehicular sales indoors, gasoline sales as part of retail operation, parking garages, and outdoor storage facilities. And that's it, Mr. Mayor.
All right, thank you so much for that, Mr. Benton. I have no other questions. Looking for a motion or whatever we want to go. That's where we are, Mr. Stokes?
Yes, that is where we are, and pursuant to our code, to overturn P and Z, it requires a 4-to-1 vote. At least 4-to-1.
All right, thank you, sir.
In what our motion, would any motion that you received be to overturn their ruling on the conditional use? That first?
I would say you want to take that up first, because if it's not, conditional use not reversed, and the rest of it is moot, but, yeah.
Okay.
I'll make a motion.
All right.
I'm going to make, my motion is going to be to overturn the conditional use denial for this property.
All right, we have a motion. Do we have a second?
Second.
Do we have a second? Do we have, anybody have anything to say on that?
Well,
all right.
Before we vote.
Yes, sir.
Yeah, I do. I guess, you know, my big thing is that the safety hazard that was discussed by the Planning and Zoning Commission, and it was, you know, it can't be brought up because it really wasn't part of the overall record, related to vehicles coming out of that property going across 512, basically. And I feel like that there wasn't adequate information provided about the potential impact of that. There was no police study about potential accidents on 512. There were no things like that were presented. However, saying that, that is not a reason for me to vote to not overturn that, because the Planning and Zoning Commission did not receive that information, so therefore it was not part of the record. So it can't necessarily be used as part of that. So I will support the motion, not because I don't think there's a safety hazard, but I don't think there was anything in the Planning and Zoning record that allowed them to make the motion that they made.
All right, so we had a motion and a second, and we'll go ahead and call the roll. Madam Clerk?
Councilmember Matthews.
Yes.
Councilmember Dodd.
Yes.
Mayor Jones.
Yes.
Vice Mayor McPartlin.
Yes.
And Councilmember Nunn.
Yes.
Motion carries 5-0.
All right.
I believe now we would entertain a motion for the site plan and then the waiver.
All right, so now we're on the site plan and the waiver.
I'll make a motion that we approve the waiver for the fence.
There's no particular order, so yeah, we want to just go with the waiver, and then.
I'll second that.
So we have a motion and a second for the waiver for the fence? Yeah.
Approval of the waiver, but that it was a particular, I'm getting that, I'm sorry, Mr.
There you go.
The waiver was used a black chain link fence.
Yes, yes.
So I
just-
make a motion that we approve the waiver to use a black chain link fence on the front yard components of that, correct?
All right, and you amend your second?
So I amend my second.
All right, so we have a motion and a second on that. Any other deliberation from us? All right. Madam Clerk?
Councilmember Dodd,
Yes.
Mayor Jones,
Yes.
Vice Mayor McPartlin,
Yes.
Councilmember Nunn,
Yes.
and Councilmember Matthews.
Yes.
Motion carries.
All right, the next one is
Would be the site plan.
the site plan.
Staff would recommend approval with the conditions that are listed on page 160 and 161. We had 5 recommended conditions of approval.
160, 161. Okay.
And if need, so I can quickly review those if you need explanation on any of those, or,
Do any of one of us need to hear? No?
Okay.
No, I think
I would
not.
say, Mr. Mayor, Ms. Bosworth, wasn't there a sixth one added during the meeting about no overnights or sleeping in the RV that was brought up?
yes, there was that concern that there could be that possibility. They did not add that, well, they had made a motion to deny, so they hadn't considered to add that as an additional
Okay.
consideration. But it can be, to make it formal, we're assuming that the proprietors of the business would have cameras and also make that a part of when you're signing your lease, that there can be no overstays. But if you'd like to add that to reinforce P&Z's concern that there be no overnight stays in any of the RVs.
Yeah, but I think the state law covers that anyway, right? We're covered by state law, and we can add that in to back it up if that makes
Yeah.
sense.
Yes.
Yeah,
In answer to
because
Mr.
as,
Yeah.
I'm sorry, as I previously said, you're now sitting in the capacity,
Yeah,
of PNC, so you do
absolutely.
have that
So-
authority to add that condition.
All right, thank you. So we can add that in to back up the law that already backs that up, so absolutely. That answer your question, Mr. McPartland?
Yes, sir.
All right, I'll go ahead and entertain a motion.
I'll make a motion to approve the site plan with the recommendations from staff of the 5 recommendations.
What about,
We can add in.
okay, at the no overnight sleeping?
No overnight sleeping
Yes.
with the cameras.
Yeah, I will second that. All right, so we have a motion and a second. Do we have any other discussion on that? Hearing none, Madam Clerk?
Mayor Jones,
Yes.
Vice Mayor McPartlin,
Yes.
Councilmember Nunn,
Yes.
Councilmember Matthews,
Yes.
Councilmember Dodd.
This is where we should have talked about traffic, is in the site plan review. But since it wasn't brought up at the Planning and Zoning Commission, I'll vote yes.
Motion carries.
All right, we're going to go ahead and take a 10-minute recess. Thank you. And we'll be back in 10 minutes. Have a seat. If you're going to leave, please leave. Yes. Okay, thank you. Thank you. We're going to go ahead and get started again. What we have, what we're on, unfinished business? All right, no.
No, attorney.
Oh, yeah. Yeah. The attorney's thing on the unfinished business, item 11A. Mr. Benton, or who are we starting with? There we go. Cindy?
Okay, we are bringing back to council the attorney position. So on January the 7th, council conducted interviews and held a special meeting. At that time, council decided to table the decision to hire a new city attorney, but to allow the interim attorney, Mr. Stokes, to be considered. Mr. Stokes has provided his proposed contract to provide services as the city attorney going forward as an independent contractor. The city would not be responsible for providing any benefits or payout severance, like a severance package. Council has been provided the personnel costs between Mr. Stokes' contract and an attorney who would be hired here at the city. Staff is requesting council to consider the contract proposal by Mr. Stokes with the two city attorney candidates who were interviewed on January the 7th. We're asking council to provide direction.
All right, thank you so much for that, Cindy. Let's see. Where do we want to start? Or do we need to discuss anything? Do we need to discuss? Actually, we probably do need to discuss the other ones we've already reviewed their stuff, and now we have the proposal by Mr. Stokes. Do we have any questions on that?
I'll make a statement.
Okay.
Mr. Stokes was not only a former, obviously, before myself, Ms. Matthews, or you, Mr. Jones, were up here. He was our city attorney for many years and did an amazing job. He obviously has done a good job for us because this is now his second time serving as the interim city attorney because of his ability and his resume as well. So I think with the opportunity to keep Mr. Stokes, I said from a financial point of view, it's the more prudent thing for us to do because it saves us about 50 grand a year between benefits and salary. And we maintain an excellent city attorney. So that would be my recommendation, is to go that direction. I just think it's the right move for us, and it gives us somebody that's really good at what they're doing.
All right, thank you so much for that. Sir, anyone else want to speak on either or the candidate?
I would say the same thing. I hired Mr. Stokes many years ago, and, one of the things is he served here extremely admirably, and, people fail to mention, he also led the Port St. Lucie legal department down there. He's got a lot of experience. I think some of the recent items that have come before us, as well as his proactiveness in the emails that I get from him trying to save us money here and there, because he is a one-stop shop, as well as he's a proven commodity. Anybody else we go to hire, you're taking a chance, almost like a leap of faith, but with Mr. Stokes, I think he's the perfect fit. If you need a motion, I'll make a motion to accept the contract as it set forth.
I'll second that.
All right, so we have a motion and a second to accept the contract by Mr. Stokes. Any other deliberation on that, anyone? So nothing else being up here on either of the candidates. Is there anyone from the public who would like to speak on this?
Thank you, Mr. Mayor. Damian Gilliams. You made my job very easy tonight. When I looked at the list, it was a no-brainer. You look like you're heading in the right direction. I want to commend you. I think Mr. Stokes is going to do our city justice. He's well-rounded. He is well expertise in a lot of areas, such as land development, which is important for this community because how quickly this community is growing. And I'm not going to say anything negative about any of the other attorneys on the list. I'm going to stay positive. But good luck. You got a great guy.
All right, thank you so much for that, sir. Is there anyone else from the public who would like to speak on this item? Anyone on Zoom?
No one has raised their hand at this time.
All right, thank you so much for that. Public input is closed. If there's nothing else from the council, we'll go ahead and call the roll. Madam Clerk?
Vice Mayor McPartlin.
Yes.
Councilmember Nunn.
Yes.
Councilmember Matthews.
Yes.
Councilmember Dodd.
Yes.
Mayor Jones.
Yes.
Motion carries.
All right, thank you so much. We have item number 12A, new business, consideration of resolution number R-26-02. Mr. Benton or who? Oh, Cindy? Yes.
Yep.
Go ahead.
The
Sorry
police-
about that.
The police officers have elected to change unions from IUPA to Palm Beach County Benevolent Association, Inc. The vote was 37-2. Resolution R-2602 amends the police collective bargaining agreement from the City of Sebastian, Florida, and IUPA to the City of Sebastian, Florida, and Palm Beach County Police Benevolent Association, Inc. We ask that council move to consider Resolution R-2602 ratifying the amended collective bargaining agreement between the City of Sebastian and Palm Beach County Police Benevolent Association, Inc. for full-time police officer employees.
All right, thank you so much for that. I'll go ahead and make the motion that we approve that.
Second.
Is there anyone from the public who would like to speak on this? Is there anyone on Zoom?
No one has raised their hand at this time.
Okay, thank you so much. Public input is closed. Council, anyone else?
I mean, it's a no-brainer. If this is what the police officers want to represent them, it's their choice. So, yeah.
Absolutely. Roll call.
Councilmember Nunn.
Yes.
Councilmember Matthews.
Yes.
Councilmember Dodd.
Yes.
Mayor Jones.
Yes.
Vice Mayor McPartlin.
Yes.
Motion carries.
All right, moving on to item number 12B, consideration of selecting Fraser Contracting for the police department. Who do you have, Ms. Graham?
Yes, Mr. Mayor, good evening, everyone. So the Procurement Division issued a solicitation to replace the tile roof on the police department. The solicitation was issued back in October. We received 14 bids, and of those 14, 4 of the submitters were deemed non-responsive. After the evaluation, Fraser Contracting was identified as the most responsible contractor. When the notice of intent to award was posted on December 4th, we did receive a notice of intent to protest, and the vendor was protesting the fact that Fraser Contracting, on their roofing license, there was a complaint. And in your packet, you will see that complaint as well as the contractor's response. But the complaint was filed regarding the subcontractor having an additional crew on site and that additional crew not being registered to the subcontractor. So at that time, they had DBPR came out. They did on that same day, somehow when they had that crew out there, they noticed that that crew was not assigned to anyone, so they did fine the contractor that was over the project, which is Fraser Contracting. But Fraser Contracting paid a fine, and the complaint was closed by the time that the bid was opened. So it took that information as well as their letter and the complaint that we received, took that to the using department, which is the Parks Department and Facilities that is purchasing it. And a decision was made to move forward with the award since, again, all of the references and everything else were intact, and they were, the references were glowing references, and the fact that the complaint was filed and closed prior to the bid deadline. So We are also asking, in addition to the bid award price, we're asking to spend up to an additional $80,000 for repairs. So in the bid, you will see there are unit prices for the wood and fascia replacement, but we won't know until they actually take the roof off which parts are damaged and which is not, which is why there were no quantities included on that. So we're asking for a not to exceed amount. If they somehow have to replace all of the wood on the police department roof, you are looking at almost $30,000. So that's why we did say up to $80,000 to cover both of those. In a good scenario, we don't have to spend anywhere near that amount because there's minimal damage under the roof, but we just wanted to make sure that we had an amount that would cover us in case we did have significant damage. So with that, I am asking on behalf of the Parks and Recreation Department for the council to approve awarding the contract to Fraser Contracting and approving purchase orders up to $208,078.16. That amount includes their bid amount as well as the $80,000, the up to $80,000 for any repairs that might be necessary once the roof is taken off. And with that, I'm open for questions.
Just one question. I think a lot of times when roofers come out to do the roof, they don't know what's underneath, so they automatically include a certain amount of plywood in the contract or anything. And notwithstanding, if they get in there and there's more, then obviously you would have to pay for the additional. Is that in this contract anywhere, or is it just whatever wood needs to be replaced, we'll know it at that time?
So the way that the engineer wrote the specifications, they just did it as a unit price. So we did have specifications that were written by Kimley Horn. They did it as a unit price. They did not provide an amount, so we just went with that. So I do understand what you're saying, but we did not issue it out that way in the solicitation.
Okay. All right, anyone else have any questions for Ms. Graham?
Mr. Mayor, even if we put a 10% contingency on top of this whole thing, it's still substantially below the budget. So I move we approve the award of the contract.
Second.
All right, thank you so much. Now we have a motion and a second. Any other discussion from us?
One other thing, I'm sure there's people going to read this and they're going to say, well, why on earth did we hire a roofing company out of Maitland? There wasn't a roofing company from the area that submitted a bid for this. So for all you people that want to say that, talk to all your local roofing companies and say, why aren't you guys submitting bids when the city's doing work? Get in and submit bids so we can give it to local businesses. We can't give it to you if you don't submit a bid.
Yeah, absolutely. Thank you, sir. Is there anyone from the public who would like to speak on this? Anyone on Zoom?
No one has raised their hand at this time.
All right, thank you so much. Public input is closed. Madam Clerk?
Councilmember Matthews?
Yes.
Councilmember Dodd?
Yes.
Mayor Jones?
Yes.
Vice Mayor McPartlin?
Yes.
Councilmember Nunn?
Yes.
Motion carries.
Yay, there he is.
All right, next item is item 12C. Is that Mr. Sabo or is that you still, Ms. Graham, or both?
It's both. I will
Okay.
get it started and go over the procurement items, and then I will turn it over to Mr. Sabo to explain why we are here today.
Very good.
So this is a change order to the contract that we have with Dickerson Infrastructure for the taxiway G construction. If you remember, back on August 12th, we did award a contract to Dickerson Infrastructure for the construction, and because this change order is, so during the second phase, the contractor ran into an unforeseen condition, which is additionally, they ran into an unforeseen condition. I don't know why I can't talk today. They ran into an unforeseen condition, and they ran into what's called muck, and so that's never happened at any location on the airport at that level. And so it was something where we needed to stop work. We had to get our engineer involved, engineer of record involved, and we had to call out Mr. Sabo and Mr. Benton in order to take a look at it to determine how we would proceed. So that did increase the cost of this contract. We also had to increase the time because it took additional time for them to go through this unsuitable material and get it back to where it needs to be so that they can continue on with the additional scope of work that we added. And I'm also adding in days because when I did the calendar, I did not account for the holidays. So generally when I do a schedule, I account for the holidays and I build those in. I did not do that on this one. So that's where some of the days are coming from. And that is outlined in an exhibit on the change order. And then the last item was just, we are modifying the liquidated damages to combine phases 1 and 2. And then we have the completion date with phases 1 and 2. Those were combined together. And then we have the phase 3. So that's my portion of it. But to explain the conditions and what was found, I will turn that over to Mr. Sabo.
Good evening, Council. Basically, what came about during the design and engineering phase for this project, they go out and randomly select certain parts of the footprint, which was an old runway that has existed there since before the time that the city took sponsor ownership of the airport itself in 1959. So it was assumed that the random spots that they would pick would give us a good general overall view of the base and sub-base materials. And it just so happened the one particular area that was not picked up under this assumption was at the joining or the intersection of the new taxiway Golf and the existing taxiway Bravo, particularly in a section where there's a radius that allows for a smoother turn in and out of the new taxiway. They dug in there and kept going, and basically Jessica called it muck. It was very much muck. We were down into the water table and basically the consistency of peat. This was all pulled out. It was replaced by 2 successive lifts of about 18 inches deep of crushed concrete. They finally reached the compaction and stabilization numbers that they needed, then came in with more crushed concrete, and now at this point we're placing asphalt over this repaired area, and we know that it's structurally sound.
All right, thank you so much for that, sir. Anyone have any questions for Mr. Sabo or Ms. Graham on this?
Do we think we found all the potential catch-ins here in this project?
Yes, sir. At this point, we are progressing, and all the base issues have been completed. We are confident that we're in good shape to finish everything up. It has cautioned us for future projects to take a look at some of these areas with a little bit closer samples to make sure that we don't miss any broad areas like this. And the terminal apron project, we've actually found 2 spots there. And we will be amending what we'll be asking the FAA in terms of funding to help us out for the difference of what we thought existed and what didn't.
Okay, because the new total amount of this is substantially less than the grant. Are there other things we can do with that grant funds?
Unfortunately not. I initially approached the FDOT because the next portion of this, once the taxiway is done, we wanted to put in a new apron to serve this taxiway, and then of course be able to have ground leases and build hangars along that area. We came up with a cost close to about $500,000 to be able to do so. FDOT turned us down and felt that that was too much of the consistency of a second project that is already scheduled, which is to build the first phase of the Gulf apron, approximately 700 feet long. So unfortunately, we are stabilizing that area. We've only scraped it. We're putting about 1.5 inches down of asphalt to make it somewhat usable. But when that grant finally comes through for the same area, we'll end up pulling it up and replacing it along with some of the base material that's necessary. We've also asked them to see if we can make some changes based on that stabilization area. We're still waiting for their reply, but we have previously accounted for that money, and we're safe to finish the project as it is.
So we're going to have to give back, I don't know, $500,000-$600,000 of the grant.
Well, technically, we don't give back. We don't get it until we spend it. Right.
Yeah, we don't spend it, which means, and the reason I bring it up, which means we don't spend our discretionary sales tax match money either.
There you go. There you go. Absolutely. We were shocked and yet very pleased with the bids that came in. All 3 bids were substantially lower than the projected cost, and the project is progressing pretty much on schedule and within budget, with the exception of these surprises that have come up.
Okay. Mr. Mayor, I move approval of this item.
All right, we have a motion. Do we have a second?
Second.
We have a motion, 2 seconds. Any other discussion? And anybody from the public who want to speak on this item? Anyone on Zoom?
Not at this time.
Thank you so much. Public input is closed. Madam Clerk?
Councilmember Dodd.
Yes.
Vice Mayor Jones.
Yes. Who?
Vice Mayor McPartlin.
Yes.
Councilmember Nunn.
Yes.
Councilmember Matthews.
Yes.
Motion carries. Did I call you Vice Mayor? I'm sorry. Mayor Jones.
We got it. We're fine. All right, listen, now you got me off track now, okay? Let's go back on track. Why don't we just finish with Mr. Sabo on C, right? Now we're on 12D. Who do we have? Oh, here we go.
Yep.
Ms. Graham, Mr. Sabo again.
So
Take it away.
This is a change order to amend the CSA that we have with infrastructure consulting and engineering. So this goes hand in hand with the project. This is the engineer of record. Since we had to attend to the unexpected situation that led to more hours, inspection hours for the engineer. So we are asking for an increase in the funds for the engineer to make up for that.
All right, thank you so much. Mr. Sabo, did you have anything to add to that? No?
She covered it very well. The engineer of record, infrastructure consulting engineering, they are very hands-on. When the problem arose, they did the extra calculations necessary, made sure that the contractor met all the specifications per FAA and FDOT regulations. And with their extra time and all the engineering work, plus their on-site time for quality inspections and control, this is to compensate them for the extra work.
All right, thank you so much for that. Anyone have any questions for staff?
Mr. Mayor, I move approval of item 12D.
So we have a motion. Do we have a second?
Second.
So we have a motion and a second. Any other discussion? Hearing none, Madam Clerk?
Mayor Jones.
Yes.
Vice Mayor McPartlin.
Yes.
Councilmember Nunn.
Yes.
Councilmember Matthews.
Yes.
Councilmember Dodd.
Yes.
Motion carries.
All right, next set. Oh, it's not going to be a set, it's just going to be one. Lee, you can handle it by yourself? All right, come on down. We're going to go to item 12E, consideration of purchase order for asphalt paving systems. Mr. Pleward.
Good evening, Mayor Jones and council members. Before you have our Phase 4 repaving project for Mill and Overlay and FDR. Earlier in October, I was here for paving for preservation work. This evening, we have $1,704,331.38 for Mill and Overlay and FDR. The following roads that we're going to be completing is Periwinkle, Joy Haven, Schuman Drive, Veterans Memorial Way, a short section of Bevan. Of the $1,704,331.38, the allotted budget was $2,447,500. We previously encumbered $500,000 to E-Step Construction, which you previously approved up to $700,000. We kept that under. We gave them a PO. We encumbered a PO of $500,000 for E-Step, and then we also encumbered $25,000 for Florissant, and then $174,000 for heavy civil for driveway culverts, and then another $3,500 and $36.72 for Palm Bay concrete driveways and head walls, totaling $711,572.72 that's already been encumbered. Our total available balance for our road reconstruction for the year remains at $1,735,927.28. So we roughly $30,000 in excess in reserves for this year's project.
Which one of those roads are getting the FDR?
Yeah, Periwinkle, a short section of Bevan, and then majority is Periwinkle and Brittle Court.
Oh, yeah, okay. And we call it Veterans Memorial Way, that's just getting a 2-inch overlay, right?
Correct.
All right. I don't have anything else. Mr. Benton, do you have anything?
Yeah, Mr. Mayor, I just want to, it was brought to my attention, and we will take ownership for this. The math didn't math under the previously encumbered, but it didn't math in a positive way, so I think I was just trying to keep Lee from spending more money. But the total in already encumbered should have been $702,536.72. So it's a reduction in what's shown here of $9,035.97. So the available balance was actually higher than what is shown in the agenda. It is $1,744,963.25.
And Mr. Mayor, I'll move we approve that amount.
Second?
Second.
I just said second.
Oh, I thought you were asking for a second.
Oh, yeah, second. Yeah, I got a second.
All right.
Okay, great. So we have a motion and a second. Is there anyone from the public who would like to speak on this item? Anyone on Zoom?
No, at this time.
All right, hearing none, public input is closed. Council, any further deliberation from us?
I just want to say that for years we heard people tell us that we weren't moving fast enough to fix the streets.
Oh.
And the city is now moving just about as fast as we can afford to make them move.
Yeah, I think they've
in
done
trying
5
to get
years
street
worth of
repair
work
done,
in the
so-
last year, right?
Yeah, so there's a lot of positive things being done when it comes to actually trying to fix the bad streets in the city. So it's a good news.
Yes,
I
sir.
know people talk about the swales and the culverts, and part of the project, obviously, you all know when we agreed to do it, we agreed to fix the culverts and the swales and the driveways on the roads that we're repaving. But, I mean, if you look, that's $700,000 it's costing just for the culverts, driveways, and swales on these roads that we're doing. That's a huge amount of money. I mean, it's a lot of money to fix those. So just so people understand how expensive this project is. I mean, that's not a lot of roads for $1.8 million, for $1.7 million roughly. It's not a lot of roads, but they're not cheap to pave. Thank you.
Yeah, I think the average cost is about $1 million a mile anyway, right? Or was it more? Is it more now? Don't answer that. Don't answer that. FDR, yes.
FDR.
Okay. All right, so no other discussion, Madam Clerk?
Vice Mayor McPartlin?
Yes.
Councilmember Nunn?
Yes.
Councilmember Matthews?
Yes.
Councilmember Dodd?
Yes.
Mayor Jones?
Yes.
Motion carries.
All right, move on to item 12F, consideration of budget calendar for preparation of annual budget. Big Brian, Mrs. Stewart. He's had a smile at least.
Good evening, Mr. Mayor and Council.
Good evening.
Before you have the proposed 26-27 budget calendar. It was designed based on prior year, and you will see in September the school board and county budget hearings that we anticipated on those dates in September. And before coming in, I did check, and it appears the county has set these dates on September 9th and September 16th for their budget hearings. However, the school board, it doesn't appear has set those yet, but that's we expect those on that one on September the 3rd. So be glad to entertain any questions or make any changes you wish.
Yeah, Mr. Mayor, I just want to highlight we've set the budget workshops for July 15th and 16th to review with departments as we have done for the last 2 years. So, if you all can kind of look at those dates and make sure those dates align with your schedules, or if there's anything you would like to add to our budget calendar as we go through this process.
I'm going to take those 2 days off for vacation this year because I can't think of a better way to spend 2 vacation days than here with y'all talking about budget.
Yeah, I'm going to take those days off too.
Oh, are you? Okay, good.
So I can be here.
We do have a kind of an employee program for psychological help.
Are you speaking from experience? I'm not sure. All right, it looks good to me. I mean, I'm good with those dates. Everyone else, anyone has
do we need to make a motion to approve?
No, we can just have a consensus.
Consensus, okay.
I want to make sure everybody's good specifically with July 15th.
Yeah.
Make sure everybody's good with July 15th and 16th.
Yeah, you made that point clear, sir. July 15th and 16th, we got it.
Fred's off.
We're going to be here for you. I'm going to take off just for it.
Perfect.
All right. No. All right, city attorney matters, Mr. Stokes.
Just a couple things. One is I sent you an email today about the property at 100 Veterans Memorial that was subject of an RFP. It was going to be a downtown brewery. That property has been listed for sale, trying to protect the project that they had contracted for. So I wanted to get council's consensus that whether it's okay to move forward with litigation if necessary. The reason, normally we might not jump to that quick, and we don't necessarily have to pursue it, but if we file it, then we can file a lis pendens, which will keep the title from transferring. And so that's the best way to protect the city and that contract that we have. So if that's acceptable to the city, I'll continue to work moving forward on that.
Yes, sir.
Yeah.
Okay. And then the only other thing is that I appreciate the confidence you've shown in me, and hope to do you proud on that. And you know where to find me if I'm not meeting your expectations. Don't hesitate. Let me know. I'm sure you won't. So thank you very much.
All right, thank you so much for that. Mr. Benton.
Thank you, Mr. Mayor. So a couple of things that I have. The first is at the last council meeting, council gave us direction to plan and put together a couple workshops on property taxes. So in working with staff, we've got two proposals, two proposed dates that we feel as though would work. We've got 3 different time slots on those 2 dates, and I just want to run those by you all. February 24th. So we have a council meeting on February 25th. So February 24th, 10 a.m. and 5 p.m. So we get a morning session and we get an evening session. And then February 25th, we have a council meeting at 6. Yeah. So we're proposing a workshop at 2, so that we get a morning, an afternoon, and an evening session across the 2 days to do 3 total workshops on property taxes. And just so you all know, our plan is to put together, obviously, a presentation that really outlines and showcases what property taxes are used for, and how any potential impacts, because as you all know, there are so many bills, we couldn't possibly run through every single possibility of what's going to end up on the ballot. So our plan is to just showcase every single thing that could be possibly impacted by a reduction in property taxes, revenue for the city, how we could potentially make up that revenue. That's a difficult discussion, and it's not something that would have been run completely by council, but they are options that we would like the public to be aware of, and make sure they're aware of some of those options that are out there. And then, really open it up to the public to allow them to ask questions. I've asked every department head to be here in attendance in case there are any questions that, for the most part, between myself and Mr. Stewart, we should be able to handle most of it, but I want all departments heads here just in case. And then that way we can showcase what the potential impacts would be on a reduction in property taxes and what impacts residents would see in regards to those reductions. So those 2 dates, anyone have any major issues with those dates? Obviously, you all don't have to attend all 3. You can if you want, but just wanted to make sure, those options were out there.
I will let you know now that I will be out of town, out of state that week.
Okay.
So I will not be for the council meeting either.
Okay.
Just so you know.
And we will record it, obviously, so you can see, the discussion that's had. We'll run them the same as we did the other workshops. We'll try to get microphones to the public as they're there. If you remember, the reason we chose to do a morning and an afternoon, so 2 daytime and only 1 nighttime, is if you remember in our past workshops, we saw a lot better attendance during the daytime than we did at night. in our workshops when we did stormwater workshops and park workshops in Riverview Park and stuff. So that's why we stuck with offering a morning session and then an afternoon session as well.
No, this is a good thing to do for us, obviously, because it will educate the public on what could happen depending on what the legislature decides, because there's been a big push in Tallahassee for that. So it's important for our residents to know that this is not going to be a tax break, that it's going to be a shift to somewhere else. So it's important to educate them on that. So I look forward to those workshops.
You might have a better idea by those dates also what's going to possibly flow out of Tallahassee. They're consolidating down to just a couple of those items right now, it seems like, so.
Yeah, and I will say we had a Indian River County city manager get together this week, and all of us are kind of on the same page, and we're going to continue to meet and work so that, you know, our message is similar across the county amongst the municipalities. It was the city managers that met and ensuring that we're all kind of in alignment with that.
All right, thank you so much for that. You have anything else?
I do. So the other item that I have for you all tonight is, as you all are aware, there have been some discussions amongst future developers in regards to community development districts, so CDDs. And that's a little bit of an unknown. We do not currently have any within the city. The county, if I believe I'm correct, that they currently do have one that is approved, but it has not yet been built, Liberty Park. And so one of the things that we've discussed and we've been approached to kind of offer this as well is to do a CDD workshop. It would be an opportunity the public can come, but then also an opportunity for you all to be here, sit on the dais. We could, you know, do it as a special call. We could do it as a workshop, however you all want to do it. But you can ask a lot of the questions, because I've spoken with each of you about CDDs in the past, and a lot of questions pop off. So in that presentation of kind of what CDDs are and the involvement would involve a CDD attorney, and it would be from a firm that represents a lot of CDDs across the state. And then also kind of a general manager or an overseer of a CDD, overseer of a board within a CDD. So you would get kind of those elements of it and be able to ask them a lot of the questions. Obviously, Mr. Stokes and I have had some discussions on this, and I know he started doing some research on an ordinance that we potentially will be bringing back to you all on CDDs. But I think it would give us a good opportunity to get answers from people that deal with it on a daily basis and are heavily involved in CDDs. So is that something from a consensus that you all would be interested in? We would be looking at the February timeframe, would be my guess on that, and kind of looking at that.
Yeah, Mr. Mayor, I would be interested in that, but I'd kind of like, if it's possible, to see a potential draft of whatever kind of ordinance that the attorney comes up with. That might drive some of the questions and comments that come about. Just as a reference point. I know the problem with the legalities of it. We have to do first reading, second reading, but I'm assuming we could probably review a draft of that even before we get to the first reading without it being any problem, maybe.
That's fine on my side. In fact, you know, I've got a lot of it done already, and I've dealt with CDDs a lot in other places. There are definitely some positives and some negatives, and I can go ahead and set some of those out to generate some questions and everything. Absolutely, no problem.
Yeah, I mean, it is something we're going to have to deal with, and I can remember watching the meetings when the county commission dealt with Liberty Park. They had an awful lot of things that flowed through the process there when they did that. So I think it's a good idea.
Okay, so we'll work on that. Obviously, Mr. Stokes has already started, and he shared some of those ideas and thoughts with me today. So we will work on getting a workshop set up. We'll contact the entities that need to be involved in regards to an attorney and an overseer of a CDD to see what availability they have, and then we'll get something scheduled.
All right. Anything else?
That is all that I have for tonight.
Well, you look like he had a puzzled look. Are you sure that's all? That's it?
That's
okay.
I hope so.
Okay. Madam Clerk?
I do have something.
Ooh.
I just wanted to mention that we started our charter review committee meetings, and we had the second meeting last night. And this is a committee that only meets, every 5 years. So we've got a great group, and I'm looking forward to hearing the ideas that they come up with. And our next meeting's next Monday, so if you can, listen in. That's all I have.
Absolutely. Thank you so much for that. Mr. Dodd.
Well, I just want to wish our mayor a happy birthday, and ask the ladies in the audience just where they plan on taking him for dinner, and get him a good one. And Jack Black will be there, so you'll be okay.
All right. Thank you so much, Mr. Dodd. I appreciate that. Ms. Matthews.
Well, it's hard to top that one. I just want to do my shout outs to the youth of this community. Aaliyah Hilliard, who is Sebastian River High School, she placed was chosen in the 2026 Music FEMA All-State Chorus, and she's getting ready to go statewide. There was 12,000 students that participated in this, and out of the 12,600 were chosen, and she was one of them, and congratulations to her. Also, Lady Sharks basketball, I told you they were going to finish strong, and they did, and they're hosting their first game of districts the February 4th, and girls weightlifting, or the district winners, they were runner-up in the Olympic and a co-champions in traditional, and they head off to regionals tomorrow. I'm just telling you, we've got Salem Olympians in the making here. We've got some good people here. And another thing is they did choose the valedictorian and the salutatorian. Sarah Van, and I apologize if I'm really slaughtering this last name, Van Zydam is the valedictorian, and Julius Lewis is the salutatorian. And I actually met him today at lunch, and what an amazing, amazing young kid. We'll see him again. That's it.
All right. Thank you so much. And I have nothing. Mr. McPartland.
I'll let you have the time. Enjoy your birthday.
Thank you, sir. Mr. Nunn.
Happy birthday, and thank you.
All right. Thank you. This meeting is adjourned.